Hi, and welcome to this DPN webinar in partnership with Waterford Technologies. I'm Philippa Donn, and if you'd like more information about our data protection consultancy work and training, please do visit our website, dpnetwork.org.uk. On the website, you can also find lots of articles and guides that we've published. To ask a question as we go along today, you should, on the right hand of your side of your screen, be able to see the chat function. So please do ask questions as we go along. Also to let you know that the webinar will be recorded and everyone who's registered will get a copy of it tomorrow. Without further ado, I'd like to hand you to our wonderful chair for today, Robert Bond.
Thank you. And thank you, Phil, for the introduction. As you can see today, our webinar is overcoming DSAR and FOI challenges, and in partnership with Waterford Technologies, who are sponsoring today. So thank you very much to them. Waterford offer a fully managed software service, from managing workflows for records requests to fast, powerful search and encryption for email and file data archives. You can see on the slide here the range of clients that they've got, both in the UK and elsewhere. And I know that Mark is going to talk where we require about the technology, but on a neutral basis. So can we just go to the next slide? Quick introductions. Well, Phil has very kindly introduced herself. I think you all know me. I chair the DPN advisory group, and I'm also senior counsel with Privacy Partnership Law in London. Mark Mulcahy, who I've just mentioned, is Client Relation Director with Waterford Technologies. And then Redwan Seruk, who's Head of Information Governance and Risk, NHS Integrated Care Board of Hertfordshire and West Essex. Hertfordshire and West Essex. Redwan is going to be our go-to guy for anything that is FOI. Excuse the rhyme. Without further ado, I'm going to hand back to Phil, who's going to do some scene setting.
Yep, so we just wanted to do a kind of just a quick refresher. So a DSAR and FOI, what's the difference? Sometimes there can be confusion within organisations about the difference between these, and certainly from members of the public. So freedom of information requests, over 100 countries have implemented some form of FOI legislation, and these can differ slightly. So we've got the Ireland FOI Act, the England and Wales FOI Act, Scotland FOI Act, and numerous ones in other countries. And under this, people can request specific information from public bodies, such as government departments, local authorities, and the UK's NHS, for example. A data subject access request is, a right that we're awarded under UK and EU GDPR, and people have the right to request a copy of their personal data from any organisation, whether it be commercial or public sector. There are similar rights in other countries and certain US states, but again, the scope and requirements can differ slightly. So a data subject access request, just a top level kind of look. People can request a copy of their data in writing, or they can request it verbally, or they can even ask via social media should they want to. And it's a right to receive a copy of personal data plus any other some other supplementary information. Organisations are allowed to seek clarification, but they can't force the scope to be limited. So if somebody asks for a copy of all their personal data, you can't force that to be limited. In responding to a DSAR, we've got a duty to protect the privacy of others, and there may be certain exemptions that may apply. We can refuse a request in part or in full if it's manifestly unfounded or manifestly excessive. We can't charge a fee unless, of course, it's manifestly unfounded, manifestly excessive, or somebody asks for further copies of what they've already received. And the crucial thing is we've got a tight time frame to respond in, 1 calendar month. And it is possible to extend this to up to a further 2 months if a particular case is unduly complex. And the key thing I want to say about this is it's not a right to receive documentation. If my name appears on multiple different documents, but only my name appears on those documents, then I don't have a right to receive copies of all of those documents. Much in the same way that if my email address is forwarded is in an email chain, but it's just my email address and there's no other personal information about me, I don't need to see, or the organisation does not need to provide all of those emails. I'm just going to hand over to Redwan now to give us a quick overview on FOI.
Thanks, Phil. So while DSARs are more about personal data specific to a singular individual who has the right to access their own data, FOI is more about openness, transparency, governments or public authorities being accountable and kind of being open with what they do and how they make decisions and so on. So the Freedom of Information Act for the UK, or depending on what part of the country you're from, allows information to be disclosed under this act. It allows anything to be disclosed. The term used in the legislation is just information held by a public authority. So it can be quite broad. For a request to be valid, it must be made in writing. It has to have a clear, specific description of the information that they're seeking. As we mentioned, because it's anything that's held, it can kind of catch quite a few documents that you might not necessarily expect. Things like audio and video recordings, photographs, emails are, I think, probably familiar with people that deal with DSARs already, but it could be anything, including paper documents. So if people request something that specific, then they may be entitled to it, depending on exemptions. And moving on to exemptions, there are two types. Obviously, because it's quite broad, it would be quite scary to have to disclose absolutely anything and everything that was requested of you. So there are some exemptions that may apply. Absolute exemptions are exemptions that apply typically to the category of data, and they are absolute. So for example, somebody's personal data. In certain circumstances, that is just going to be exempt. You can't request somebody else's information under an FOI request. So that's just going to be exempt based on the category of data. But there are other exemptions called qualified exemptions. Those are where you may be able to use that exemption, but you have to demonstrate that you've done a balancing act where you've considered the public interest in disclosing information versus the public interest in protecting protecting the interest of the public authority or removing a prejudice that might come up. This might be for legal professional privilege, for example, to give you some examples, or indeed a number of other exemptions that may apply. Under the Act, you have 20 working days to respond. This will vary depending on the different types of legislation or different variations of legislation, but typically they're about a month. So they're 4 weeks, 20 working days. They all work out roughly to about a month. You can charge in certain circumstances. An FOI request is free as standard, but if it takes longer than 18 hours for public authorities or 24 hours, this is staff man hours, 24 hours under a central government, then you can charge. You can also refuse, which I must admit is usually the popular option, but you do have the option to charge after that point. And so there is a clear difference between the two in terms of the information that you can request. If it's personal data, then it would be considered under the UK GDPR, Data Protection Act 2018. If it's information held by a public authority, then it's more under the FOI Act. I'll pass back over to you.
So just wanted to take a little look at some action that's been taken recently by the ICO. So we've had back in the autumn, the ICO, a bit of a flurry of activity where they issued a number of reprimands to public bodies, including government departments and London boroughs, for failure to comply with DSAR requirements. There was also a reprimand issued to a commercial media company. A key issue here is a failure to respond within the time frame, and organisations ending up with a substantial backlog of requests. We also anecdotally know of organisations receiving letters from the ICO due to DSAR complaints being raised with them. So sometimes these letters might ask for an explanation for you to go back to the ICO, or they might ask you to try and resolve whatever the issues are with the individual. It's interesting to note that DSARs account for 1/5 of complaints received by the ICO, and that's based on 2020-21 figures. Some freedom of information request cases have been upheld, and there was a recent action, FOI enforcement last week against the London Council, where they've been ordered to respond to all the outstanding FOIs within 6 months. And there's also obviously cases across Europe and I know very recently in Ireland there was a case where the Data Protection Commission has ruled that the proof of ID that was requested by Airbnb for a DSAR was excessive. So there's certainly action happening, and this represents some risks for organisations. So we've got the risk that we could disclose information in error, or we could fail to provide all the in-scope data. Obviously, for a lot of the people that have, a lot of the organisations that have ended up in the spotlight of the ICO, there's a failure to respond in time. But also there's the fact that for business organisations, there's a risk of rising costs in responding to these requests and lost time. Anyway, I'll now hand back to Robert.
Thank you. And as Redwan and Phil have been talking, there's a huge number of really good questions coming in already, and we'll get to the questions shortly. There's some more scene setting that we'd like to do, but just before we do that, we'd like you to answer a couple of quick polls that we've got. So if Simon, we could launch the first poll, please. Are you able to respond to requests in time is what we're asking. So do give us your answers, and I'm seeing people kindly responding to this poll. Are you able to respond to requests in time? Percentages are changing at the moment, so I'll give it a few more moments before we close the poll. I'm intrigued to see how many people are very positive here to the answer yes, always. I find in practice it's pretty tough to always respond in time, but we'll get back to that in a minute. So it looks like we're there with 70% saying yes, always, 26% no, sometimes miss the deadline, and no, 3% frequently miss the deadline. Thank you. Can we just turn to the second poll now, please, Simon? This is, are you confident in your processes to handle DSARs and or FOI requests? And we're looking for answers to yes, in part, and no. Not so much confidence with this one. We're looking fairly evenly split between yes and in part at the moment. So I think we'll probably call that to a close. We've got 48% of you say yes, we're confident we can, our process works. 45% in part and 6% no. So it sounds like everybody is reasonably on top of this. Thank you for answering this. What I'd like to do, and again, for those of you who've sent questions in, I will get back to these in a moment because they are really good ones. But let's just go around the panel. And I'll start with my own thoughts here, that what I wanted to know from each of us is what, in your experience, are the key pain points. And I suppose as a lawyer advising clients over the years, I've found one of the problems we have is that the individuals often confuse what's an FOI and what's a SAR. They are certainly confused to the extent they assume that these are absolute rights. And we, as the data controller, for example, have got to find a way of meeting their demands whilst not handing over anything that we shouldn't hand over or not required to hand over. It's never, in my view, a win-win situation. Nobody ever makes these requests when they are happy, certainly with SARS, but equally I've seen, when I've been advising public authorities, that there's a lot of confusion as to when a SAR is a SAR and when an FOI is an FOI. And some of the questions that we've had in are around that. But Redwan, let's go to you. What are the pain areas for you?
Firstly, I agree with what you mentioned. I think greater understanding of certainly the exemptions and how the law works will certainly improve things quite a lot, I think, for a lot of people. And there are a lot of professionals that's still learning as well. But the key pain points, I think, identifying and retrieving the information. And identifying, I think, shouldn't be underestimated here. And I know we're going to talk about that a bit more later on. But actually just identifying what it is that you actually hold and whether it's in scope or not. And then the actual processing of that information, the retrieval if necessary, and then the potential application of exemptions. And then just a quick point on resources. I think those are probably the two biggest ones, I think, will affect a large number of people. Having the right amount of staff, time, resources in general, including the type of technology that would speed things up, and whether a public authority or indeed an organization has the right tools to do that. And I think that they're probably the key pain points for me.
Okay, thank you. And you just mentioned technology, so I'm going to turn this one to Mark. Dealing with your client base, what have you seen are the pain points for them?
I think I'm on our 1,600 clients. The pain points in this area has been clearly defining the workflow of managing these processes. It can often be deemed to be in place, but it's not stress test until it's a live scenario. It probably, because we're 20 years old, it probably was okay when the volumes were lower. So, a combination of the volumes increasing, the awareness and the public increasing around this space, incidents growing, and, then also, from the ICO or the DPC doing audits and explaining that they're going to be more in this area. So the activity and the awareness is increasing. So when that volume increases and the activity increases, they need to then switch from the manual processes that they could do, where maybe they had a couple of dozen a year. If it's moving into a couple of hundred a year or multiple dozens, that's where technology needs to come in, where they need some help with the scale and the scope. Still pretty simple questions I need to ask, who's going to get the data? Where is the data? How are we going to collate it? Who's going to review it? But if we don't have some help around technology to do that, then hitting those deadlines, which 75% of people can do currently on this call, is either going to get harder in the future, or maybe if they stress tested that process, clearly and honestly, it may need some help. And that's where we come in with our clients to try and help.
Super. And Phil, what are the pain points you've experienced?
I think you've largely covered most of them. We did a survey of our DPN audience last year and identifying, and the key kind of challenges with DSARs was identifying requests, as you've mentioned, having enough resource, enough experienced people who know how to manage them, email searches coming up as a major pain point. What to redact and how to redact it efficiently. Accessing relevant systems was seen as a key challenge as well. And also the sheer scope and sometimes the volume of information that you're dealing with. And just the time that it takes. It can take hours if you're doing it manually. And then where you've got more complicated cases where you feel that DSARs may be being weaponized, or where you've got other things overlapping with it, making it more complex. So it might be an ex-employee and a grievance procedure just making that a more tricky and complex process to go through, where you need to apply exemptions, etc.
Thank you. And certainly in the last year, I've had a number of exchanges, or I've had a number of conversations with the ICO, and one or two of you have commented upon how the ICO are amenable to commenting, but they'll never advise. Certainly, I've seen situations where the biggest challenge is the sheer volume of information that you've got to look through.
Yeah.
And also the fact that personal data could be identified in numerous instances. In other words, it's not just what you've got on the system, it's what you've got in terms of voice recordings, in terms of CCTV footage, in terms of information on other devices that are corporately managed, and indeed social media accounts. So there is a huge area to search. And I wanted to put this to Mark. How does the technology enable you to search all these different areas where there may be DSAR related data or FOI?
Well, I think, you need to understand the types of technology out there that's going to make this process a little bit more efficient and to streamline it. But again, for our clients, it's pretty basic when they're asking me. I mean, the first step is, to build some best practice into the mundane, which is that data. We sort of focus on, do we know the law? Do we have the process? Do we understand, do we have the right forgotten? Is that, an unnecessary request that we can decline? But when we have the information that we are agreeing to find, do we have a process in place to know where it is and how to get it? The real problem is traditionally IT and compliance teams have not been working very closely together, and that really needs to start happening now, because the IT people should be the go-to department for compliance team to make this process more streamlined. If you're not required to have ROPA records, maybe do have a understanding of where your data is. Use metadata, and that's where the technology starts to come in. Use metadata that helps you identify and find different structured data across your organization. We have technology built for most business processes. DSARs, FOIs, even EIRs are now critical business functions that we need to start applying technology to, in anticipation of being able to do them correctly, clearly, with an audit trail built in, especially if they're growing and growing.
And Redwan, when you receive a request which may in part be a DSAR, but also appears to be part an FOI because of the nature of your organization, again, how do you in practice manage this process of understanding where this all is?
It's a great question. I know it comes up a lot, and I think we have to remind ourselves that it's not a requirement for a valid request for the requester to say, I want this under UK GDPR or under FOI, there is the responsibility on the organization to be able to identify what is what. And I think the first starting point is to look at what it is they're requesting. If it is their own personal data, then of course that must be included. It must be dealt with under the right regime, under the UK GDPR, DPA 2018. And I think that the responsibility is on the organization to recognize that properly. And sometimes people make submit a written request under FOI. I would like all of my data. The responsibility is on us. And I think the first thing you need to look at is exactly what class of data they're requesting. If it's their own personal data, then it will need to be dealt with under the right regime, UK GDPR. If it's anything else, then it's usually FOI. I won't get too technical, but the law does kind of encourage you. So under an FOI, there is a specific exemption for personal data, and technically you would need to refuse the FOI request, even if it's for their own personal data, and then say, I will deal with your request under UK GDPR DPA 2018, and then kind of formally set the terms of that. So you tell them it's going to be 1 month, you're telling them this is how I'm going to process you, and you're kind of setting the right expectation. And also not forgetting that if you are going to deal with it under as a DSAR, then you might need to request ID. You might need to confirm that that person is who they say they are. So you're shutting off an FOI process and correctly starting a DSAR process, but you need to do that quite early on.
And in terms of managing that process, Redwan, do you have a procedure and training to make sure that in the organization everybody knows what one of these looks like and everybody knows who is in charge of this?
I think this is an essential ingredient to being able to do this properly. Because of course an FOI or a DSAR is valid if it goes to any part of the organization. So it's essential that in your training, and I know lots of organizations will have mandatory training certainly for data protection, that you mention things like if you receive a request, knowing what a valid request looks like. If anyone requests information about themselves, you need to be able to recognize it, and most importantly, forward it on to the appropriate team as soon as possible. So it's essential that I think you include that in training. And then internally that you have a process, so it's clear who that should be forwarded to, which team, the DP team, the FOI team, and then within those teams they need to have really set processes in place where they know exactly how things should follow. So even if the should we say the correct person is not available, the person with the most knowledge in this area, the processes are set in stone that actually this needs to be followed, then it's this step, then it's this step. And it's really important. And the contact with, certainly for both FOI and DSARs, contact with all the appropriate teams within the organization, I think is a really, really important part to making sure the process is efficient. Because I think if you've got the right contacts in HR or in IT, and it's coming on to Mark's point earlier, that actually if you're working together, it does improve efficiency significantly in my experience.
So Phil, and this is one of the questions that came in earlier, when you're searching for the personal data, the particular question I'd got is if you have got on record somebody's personal opinion that they've made about the individual, do you have to reveal the personal opinion?
Yes. Can I do a short answer there? So if I'd written down somewhere, on a document, an opinion about Robert or Mark, then yes, that's within scope. Obviously, unless there's legal privilege or some kind of exemption that might apply to that, or that but on the whole, an opinion about me is my personal data. So say, for example, you were searching emails, let's say, and most of the emails only had my email address in, but then there was one email where actually there was an opinion written about me. Well, then that is going to be within scope.
And so one of the other questions we've had is, if the same personal data appears identically in numerous locations, can we not just say across various locations, this is what we've got about you, rather than having to produce, redacted 8,000 emails or text or whatever?
Absolutely. I mean, I had this question just the other day, actually, where they said, you know, we've got lots of certificates where this person's name appears on the certificates. Do we have to provide all the certificates? No. You can, you know, and there's no harm in explaining these things in your response. You know, the law tells us exactly what we've got to provide in a response, but there's no harm in providing a little bit more information and saying, you know, we've got your name and address because of the service that we provide to you doing X, Y, and Z. We've got your name and address on these, you know, X, Y, and Z type documents. And you don't have to provide every single copy if it's just a repeat of the same personal data. So yeah, I think we can reduce the volume down somewhat by taking that approach. You don't need to, you know, provide the same personal data over and over again.
And Redwan, you mentioned, I think earlier, about making sure that you've identified the individual. Do you think it's reasonable to be able to ask the individual to narrow the search criteria?
Yes, I mean, just to touch on Phil's point, I think good communication is helps a lot. And one of the things that I've kind of tend to do in all my previous roles is actually play the neutral role, because we shouldn't forget that as DPOs, as FOI officers, you are there to champion individuals' rights. You're not part of the team that they might be upset about. You're not part of the HR team or anything. You're there to help them. And actually, just kind of, even if it's a verbal conversation, if you're helping, or generally just having good communication in your responses, you're there to kind of champion their rights. You're there, yes, you're an employee of the organization, but you're there to help them. So you're not part of because of course these things can be weaponized, but you're not part of what they're really trying to, get to. And I think just mentioning that in a helpful tone and really being clear about what they can and can't have, and the reasons behind that, the legal reasons behind that, I think helps to diffuse certain circumstances. But coming into your question, yes, I do think it's appropriate to ask for more information and to narrow the scope sometimes. Of course, we can't force the scope of a request, whether it be an FOI or a DSAR, but I think it's absolutely appropriate to try and create appropriate boundaries so that you can be more efficient, so you can help them get their response quicker. So, for example, in a large organization which has many different departments, and somebody says, "I want all the information you have on me," I think it's absolutely appropriate and probably recommended that you try and come back to them and say, "Can you provide a bit more clarity? We note that you are you're known to this department, for example." So, for example, if it's a local authority which deals with education, social care, it deals with council tax and elections and so on, we note that you're known to these departments. We will search these departments and provide you, and kind of almost trying to provide some options, if you like, and say, "Is this what you mean?" And then allowing them to kind of confirm back. I think is very, very appropriate, and I would push a bit further and say recommended. I think in an all data SAR.
So what you're saying is you are appearing and you are being helpful to the individual to say, look, if you can work with us to try and narrow the criteria, we can do this faster.
Exactly that. Yeah, absolutely. And also it means that they get what they want faster, but usually sometimes we can kind of over-engineer things. They might be upset about one particular part and they say, "I want all my data." And actually just clarifying that it is just all your data within that area, because that's, sometimes their original intention anyway. And actually we can sometimes overcomplicate things. So just double checking with them and having that good communication channel, I think certainly helps.
Sorry, go on, Phil.
Just going to add to that sometimes we rely so much on emails and corresponding with people by email or letter or whatever. And sometimes picking up the phone and talking to people can solve so much. And I know it's sometimes people can kind of almost be scared of it. Oh gosh, they're going to be angry or they're going to be this. But actually picking up the phone, I know cases where a telephone call has ended up with the DSAR being withdrawn. you know, because you had that conversation, you talked to them, you explained what they would and wouldn't get, or and talked about whatever their concern was, and it's gone away.
I would definitely agree with that. And I've had very similar circumstances. And this is where the neutral approach really helps. So you presenting yourself as somebody within the organization that's there to help them, rather than, because of course we're not part of any other department that they're, you know, they might not be as pleased with, shall we say. So presenting yourself in that way really diffuses the situation very quickly and helps.
So I just wanted to move on to one of the other issues, which is for many of those that are on this webinar, you're not public authorities. What needs to be searched will be structured data. But we know that for public authorities, and indeed with FOIs, you've got to reach out into unstructured data. How on earth do you manage that for clients, Mark?
Well, the unstructured data is the real headache for people. You know, it's not a mistake. The GDPR coalition just before May 2018 called email and file the Wild West of GDPR. Just a clever term to say, as we bring this legislation in, guys, just, you know, a bit of common sense here. The hard places to find data is going to be where there needs to be a little bit of focus. And that's really a lot of what we do. So what we do is we try and build the workflow of the process in at a top level, and we try and give you the tools then to find the data sets when you delegate access to somebody to look for something. So really, there's a couple of approaches. You know, we can acknowledge the repositories that are difficult to search, and email is one of the anomalies we have in all organizations. If you get into a thought process of what it does and how it's provided and who gets it, but we can put our head in the sand and say, oh, we'll just do it, or we'll come up with a scenario. And that's why I said at the start, we try sort of get our clients, if they say we have a workflow in place, we're good, we try get them to stress test it, or we give them an example from one of our other clients in their sector to say, if this scenario occurred, walk through it, because it's when you walk through it, you can pick up the deficiencies in your processes. But really, there needs to be some core functionality built into unstructured data sets, and that's really where technology comes in. You know, so, you know, we need to be able to identify that data. So we're only going to be able to do that if we have the ability to search it, and to search it, we need something that quickly indexes that information, that can reach in and collect the precise data we want. I mean, the points Phil Arudawan were making were really good points. You know, if we did a search for an email, I want everything, and I could quickly say, well, I've just done a search in 30 seconds. There's actually 32,000 emails that mention that to you. And as Phil said, pick up the phone and say, look, is there a specific area you want to talk about? And again, if you could come back speaking just on unstructured data and type in their details with their actual query, we might reduce that down very quickly. So we need to be able to find it quickly, simply, and present it. We then need to be able to review it. We need to be able to export it, provide it to the case manager. We need to be able to defend that process. And that's one of the things that's becoming more and more into our clients, the defendable piece of that process. Each step is audit trailed, each process is built in, the redaction is built into it there. And we need to be able to defend that process and also get it done within that finite time. So if I've got 14 million emails, and the vast majority of people on this call probably would way underestimate what each of their organizations would be, whether it's email or file. How would I, if I was being honest and I was going to do a thorough process of doing my review of both those data sets, am I equipped to do that within the 20 or 24 days or 30 days? And by often, when our clients come to us, they're way off the ability to do that. So it's that mechanism, regardless of what the technology is, we do it, so do other people. You know, review that. Do we need that piece built in now, or in the anticipation that we're going to be able to have to manage our unstructured data more and more? And if you do that, guys, and you work with your IT departments, the nice thing that comes out of this is we start deleting data. And we start realizing keeping 20, 30 years of email is an unnecessary thing that we need to do.
Mark,
Yeah.
I was just about to say that, unstructured data. I know organisations now that are bringing in kind of short limits on how long Teams messages are kept for and things like that. And it's like reducing down. And I know emails have traditionally, we've all got a culture of keeping emails forever, but trying to move people away from that and not have as much unstructured data is really helpful.
Or even, Phil, having it, if you want to keep emails, query the repository it's currently in, because emails sit in a communication device whose job is to be a communication device. So there's no audit trail, there's no defendable process in an email. It's not even a full record of communication. There's no view of if any of your 400 or 4,000 employees tampered with any of those emails. Not that there's anything wrong with that, because it's designed as a communication device. And it's us in the last 40 years converted that into a storage device. And thankfully, our clients in the last 18 months, the penny has dropped and they are reverting back to saying, if I want to keep a small subset, maybe 10 years of email, I want it in a GDPR or an FOI aware repository. And you know what? I'm going to turn my email back to what it was designed in the 60s and 70s to be a communication device.
If I could come in, I found it helpful during training sessions to exactly reference the point you just made, Mark, about it being a communication tool rather than a storage tool, and actually asking people, think about your most difficult, circumstance, client complaints, the situations will vary. And if that, think about your worst case scenario of a SAR, and would you be prepared to do that now? Would you be prepared? Are you prepared to be able to process that now? I've dealt with situations where, the initial search has brought back 40,000 items, but actually because of technology and removing at least duplicates, that's come down significantly. But actually even that, it was still, a good 10,000 items that needed to be reviewed. So I think being able to kind of get people thinking before the worst case scenario happens really, really does help.
And just as another comment, when you're trying to be helpful with the individual, I've also found that it's critical to get them to confirm the different variations on their name that they use, because otherwise you will not succeed, because you'll only be searching against, for example, the name they've used in the request, whereas internally they may, on record, they may have their previous name before their name changed, they're married, or they may have a Twitter handle that they use for the corporate Twitter account. And, I've seen situations where you just fail because you haven't asked all of the questions that you should do. So, I'm assuming, again, Phil, that you recommend that do you think a template approach is the right way to go for responding to the initial request, so that you can clarify that the subject is the subject, etc.?
Yeah, no. So I would always say, acknowledge the request as soon as possible. If you can do a quick check first, you might then be able to immediately seek clarification if you know that it's going to be complicated or their request wasn't particularly clear. Ask for that proof of ID if you need it, or other form of proving their identification. So it doesn't necessarily need to be a document. There might be other ways of proving. So I would have a kind of standard template letter, absolutely, as part of my procedure, that you can tweak and adapt as per the particular request. I mean, it might be that you can just send a standard one out to everybody, or in particular cases, you might be wanting to tweak that. But yes, as part of the procedure, I would have some kind of standard templates of what I would do at different stages, including the response at the end, or so that you've got those to go to, and if you need to adapt them, you can adapt them per each request.
And again, I'll let you jump in a minute on this, Mark, but one of the things, again, I've urged clients to train on is that when you receive a SAR, assuming you're satisfied it's a genuine SAR, you almost have a litigation hold, as we call it, so that you shouldn't then be tampering with the data. Otherwise, you're in breach of the law. And I'm assuming the same happens with an FOI, Redwan.
Yes, that's correct. I mean, FOI, obviously, it's slightly different because it's more about public authority data rather than your personal data bit. But yes, essentially, whatever is held on the day the request was received is what must be considered. So if you hold something that maybe you shouldn't have, maybe you should have deleted it earlier, and you've just realized that because of the FOI request, deleting it after you've received the request would be an offense. So it's whatever is held on the day the request landed in the organization.
So Mark, assuming that everybody knows we don't tamper with the data, technology is helping with the search process, assuming that you send the response to the SAR, should you still be keeping that, siloing that data, or listening to what Phil was saying about getting, or you were saying about getting rid of data, how soon do you think you should be clearing the stuff out? The day after you've sent the response to the SAR, or do you keep it a bit longer?
I think our clients would be prudent to keep a bit longer if that's the case itself, the data collected. But, you know, when it comes to, if we go back 3 or 4 years, the vast majority of organizations had no retention policies anywhere. They were, I better keep everything just in case, because sod's law, something will happen down the road. That is shifting. There is an absolute mind shift, not in 2018 from a GDPR point of view when it came in, but in the last couple of years, my sense is it's bedded in a bit. COVID then gave people time to start interacting, but we see that. So where a lot of people are now looking at data management would be, I am going to have a compliant aware repository if it is going to store data. And if I have a repository that's not compliant aware, whether it's FOI or GDPR, I need to seriously ask the question of my organization, why are we storing that data? And if that can manage our repositories, because if we go back to email, if we think about it, there's no integrity, no oversight, no ability to understand what's happening in it. Yet it's one of the first things we give a new employee. First day you join, hi Phil, welcome to DPN. Here's a mailbox. You joined us 10 minutes ago. Go talk to 7 billion people. We have no view of what you're about to do. Redwan could leave tomorrow and edit every single one of his emails in his mailbox. We have no view. So people are finally, you know, and another really good stat I give our clients from Gartner, we look at emails older than a year on average 4 times a year. Okay, so most people would think I'm going to delete everybody's email older a year or 2 or 3, there would be anarchy. We don't go back very often to legacy mail, but we need that safety blanket. So if you're going to want a legacy blanket for data, whatever it is, have it in a repository where your FOI officer or your GPO has the tools to be able to manage that data correctly and efficiently. That should be music to IT department's ears, because that means in essence we are reducing our data sets everywhere.
Mm-hmm.
So I just wanted to look at another area. I know we've all said that we want to be as helpful as possible in meeting the requirements of this data subject, but several of you have commented, and I'm the first to admit, that some of the requests we get are weaponized, and the individual thinks this is a backdoor means to discovery. They may be, claiming compensation as a former employee. They may be seeking compensation as a consumer of a defective product, etc. And they will make numerous requests on the assumption that their rights are absolute. What do you think, Phil, is vexatious? At what point can you say we are no longer going to respond?
Well, interestingly, so at the moment we can not respond if it's manifestly unfounded or manifestly excessive to a DSAR, but obviously the bar is set quite high, and we need to be able to defend the position we take. I did have a case once where somebody was asking for copies of every image that appeared with them in any CCTV. Well, it was clearly unreasonable. It's like, well, why? Why do you need that? And that is going to be incredibly difficult to fulfill. So actually, no, we're not, unless you can say what you is there a date time? Is there a reason why you would want that information? So it is a judgment call on each individual case, and it's interesting that under the Data Protection and Digital Information Bill, they're looking to slightly change that and tweak that, so it will change from being manifestly unfounded and excessive to vexatious and excessive. And it's hoped that this will give organisations a bit more room to deny requests where they're, intended to cause distress, they're not made in good faith, or they're an abusive process. So hopefully, if of course the bill ever moves forward to become law, that may be a good thing and give businesses more grounds for denying requests, either in full or in part.
And just following on from that, so Redwan, have you seen, since GDPR came in, have you seen any trends, good or bad, in the way that individuals are exercising or organisations are responding to either FOI or DSARs?
I think there's the general trend is, I think they're all increasing. Most requests, both FOI and DSARs, and this is, I suppose, understandable and natural. More people are aware of their rights as a result of GDPR, but also privacy is a much more hot topic now than it ever has been in the past. So more people are interested to know what organizations are doing with their own data, and indeed in how governments are operating because of the media. So there is a trend in that sense. I think because of GDPR also woke up quite a few organizations to compliance, and that's a good thing. That's definitely a good thing. So I think, the trends are more people are aware, and I think there is most of the time it's genuine to use the law to improve privacy practices and indeed access your rights. But unfortunately, of course, there's always going to be an element of weaponizing the request, as you called it earlier, or abuse of certain processes.
Yeah, and I've certainly been talking to the ICO about instances recently for a particular sector where the businesses in that sector are in background checks, business intelligence, due diligence. Their role is to help other businesses comply with the law, to deal with anti-fraud, anti-bribery, etc. And we are seeing weaponized use of DSARs, particularly, to grind these companies into submission of effectively you're not doing what they're supposed to do, because they're then being bound up in repetitive, huge search criteria types DSARs, where you look at it and you go, I don't think that behind this is a genuine DSAR. This is a law firm representing an individual, where they are using the DSAR for as an abuse of the law. And I think that's where some of as Phil refers to, the suggested language changes we're seeing in the DP and DI bill, which I think for a lot of businesses will be a relief if we know that the regulator will back us at the point at which we say we are no longer responding to this request. And I'm sure, Mark, you may have had clients that have been subject to, multiple requests in a template format because somebody is driving a campaign. Have you seen that type of vexation?
quite a bit and growing quite, especially some of the local authorities or councils, both in Ireland or in the UK. I mean, almost like a service denial attack where they will just keep as many people busy as they can. And some of it is vexatious or aggressive, and some of it could almost be out of boredom. I can do this. I have rights now to be able to ask questions of my public sector for all sorts of things that will keep my day busy or my week busy. And that process, again, has to be acknowledged and has to be processed. And, you know, the changes in the law are good that, you know, we'll be able to review some of this. I suppose my question, Phil, because I get this, is will the changes on the vexatious be around the volume of requests or the nature of the request, or will it be a case-by-case basis, do you think?
Yeah, I think it would be case by case. So it could be that you're getting a series of requests from the same individual or organisation acting on behalf of someone. So yes, it could be either. It will depend on the situation.
Okay.
So, and from, sorry, I was going to say, from my point of view, the regulator is going to say, you know, you have to make the judgment call.
Yeah.
And so long as we can see that you've done some form of assessment, and I think Ridwan talked about balancing, but so long as you're balancing your position versus that of the individual, the ICO might not agree, but what happens next is not likely to be a crisis. Yes, sorry, Ridwan, you were about to jump in and I talked over you.
No problem at all. I think you're quite right. I think the evidence is really important. And I think sometimes there's quite rightly a sense of nervousness about using certain exemptions and parts of the legislation. But actually, I think, you know, we you know, as practitioners, I think we do need to have more confidence in using the full extent of the law, because there are parts of the law there designed specifically to protect organizations from this type of abuse. And it's interesting that they're using the word vexatious now, because that brings it in line with FOI. And if you look on the ICO website about the guidance for vexatious requests under FOI, they do have quite a lot of quite good advice in this area. And it's very likely that if they use vexatious, if the bill is passed and it becomes law, then actually much of the guidance on vexatiousness or vexatious requests for FOI are likely to apply to DSARs. Obviously, it will be updated and be on a case by case, but you can kind of sense that it will have a very similar flavor to it.
Yeah.
And I've certainly found when we've had somebody who is significantly aggrieved and you know that they're out to win, that of course you can quite happily send a copy of their personal data in a spreadsheet format, for example. So if the name appears in 8,000 emails, you can simply say that. Where there's an opinion given, yes, you're going to have to pull that out as a separate piece of personal data. And I know somebody commented in the chat earlier that they have found keeping the ROPA up to date, as well as having a risk register, is a great way of understanding what we've got and why we've got it and with whom we might have shared it. So, you know, going back to what Mark was saying earlier, that there's an awful lot of lessons that can be learned here. We've got about 2 minutes to go. So I'm going to ask Mark, any final thoughts?
I suppose my final thoughts on this for data practitioners is, you know, this activity is growing and it's here now. And my advice would be to have the confidence to, and I'm talking from the technology side in today's session, have the confidence to insist on the mechanism to help you through these processes. You know, we won't deploy PCs with virus software. We have security firewalls. We have archives. We have backups. Any IT department would be remiss if it didn't do that for, let's talk about the finance department. This is an integral part of organizations' activities now. So therefore, you should insist on the ability, if you need it, to have the technology to help you guys do your jobs correctly, would be my final thoughts.
Thank you. And Ridwan?
Final thoughts, probably prevention rather than cure as a starting point. I think we cover in our training, think before you store anything or send an email. Anything that you produce as an employee, as part of a representative of an organization, is potentially disclosable. If you're a public authority, it could be disclosed under FOI. If you're any other organization, including public authorities as well, it may be disclosed under a SAR if it's referring to an individual. So prevention rather than cure. And then if the requests do come in, which inevitably they will, having really clear processes and thinking about how can I streamline this? How can I gain clarity for each one so that I can deal with each request as effectively and as efficiently as possible, both for your own sake in terms of resources, but actually to reach a good outcome for the requester as well.
Thank you. And Phil?
Very quickly, I would say manage expectations from the start. Tell people what they would expect to receive, so that there's no surprises later. Quite often, I think complaints end up with the ICO because people go, well, I didn't get what I was supposed to get. But if you've managed the expectations from the start, told people, this is what a DSAR is, this is what it entitles to you, there might be exemptions we need to apply, etc., etc. Managing that from the start, and pick up the phone if you need to talk to people. It might make the SAR go away.
Thank you. And I know we're over time, and I know we didn't get to everybody's questions. I apologize for that. Don't forget that on the DPN website, there is the DPN DSAR guide. So do access that. Thank you very much on your behalf to our speakers, and we look forward to being with you on another occasion. Thanks. Bye-bye.
Thank you.
Thanks, guys.
Thanks all. Take care. Hi, Simon. Can you hear me?